Victims of sexual abuse in Illinois can file civil lawsuits and receive significant financial settlements. Sexual abuse or sexual assault can range from forcible rape to groping. Any victim of sexual abuse has the ability to file a civil lawsuit under Illinois law and get compensation. Abuse victims can bring a civil lawsuit regardless of whether criminal charges were brought. In fact, victims can sue even if they never reported or told anyone about the abuse when it happened. To file a civil lawsuit for sexual abuse, victims simply need to be willing to testify about the abuse under oath. The individual person who committed the abuse is always a potential defendant. In most cases, however, that individual probably won't have enough money to pay a verdict or settlement. To succeed in a sex abuse lawsuit, plaintiffs need to bring negligence claims against third parties such as schools, churches, or corporations. These parties can be held liable if the victim can show that they were somehow negligent in preventing the sexual abuse or failing to protect them. Over the last few years, a growing number of states have enacted new laws extending or even completely lifting their statute of limitations for child sex abuse civil lawsuits. So far, however, Illinois has not amended its statute of limitations for civil sex abuse claims. Civil lawsuits based on sexual abuse in Illinois by a priest or anyone else are still subject to the general 2-year statute of limitations. When the victim is a child, however, the 2-year statute of limitation clock does not begin until they run 18. Our firm represents victims of sexual abuse and assault in Illinois. If you have a potential claim, call us today at 800-553-8082.